Imagine waking up to find out that the federal government has completely dissolved your community.
Yeah.
Just entirely erased it.
Yeah, overnight.
Right, overnight. And they've stripped you of your health care and handed you a property tax bill that you cannot possibly pay. And the craziest part, this was all based on a single flyer that got stapled to a bulletin board on a dirt road somewhere.
It's hard to even wrap your head around.
It really is. So, welcome to today's deep dive. We are taking you into the California Rancheria Act of 1958. We've got a massive stack of sources for this one government dossiers, legislative texts, inquiries from the California State Senate Interim Committee from the late 50s, and the definitive 1997 Termination Report by the Advisory Council on California Indian Policy.
A lot of really heavy, dense reading in those.
Seriously. But our mission today is to unpack a policy that was wrapped in this soaring mid-century language of, benevolence and equality and emancipation. We're going to look at the literal text of this act, which actually promised critical infrastructure like paved roads and working water systems. And we'll contrast that with the grim, on-the-ground reality that engineered widespread generational wreckage for California's native communities.
Right, and I think setting the tone for this era of history is critical before we even start. When we go through these historical reports and legislative transcripts, we aren't reading a story of outright kinetic warfare.
No cavalry charges here.
Exactly. This isn't the 19th century. What we're looking at is a story of administrative erasure. The California Rancheria Act was framed almost identically to a municipal real estate contract.
Like a housing development deal.
Yeah, essentially. The federal government was offering to trade communal, federally protected land for individual private deeds. They presented it as this great civic upgrade. But the fine print embedded in the bureaucratic execution of that contract was absolutely devastating.
And the central irony here, the thread that we really want to follow through this entire deep dive, is that the architects of this policy engineered their own eventual defeat.
They really did.
Like, the federal government drew up this highly technical, legally binding contract to dissolve these native communities. But by failing to uphold its own end of the bargain, by skipping out on the plumbing and the paving just to save a few bucks, the government inadvertently planted the exact legal seeds for the tribe's eventual resurrection decades later.
It's quite the plot twist. But before we can fully parse the mechanics of that 1958 contract and why the federal government's failure to lay pipe and pave roads became such a pivotal legal weapon, we have to pull back a bit.
Right, we need the context.
Yeah, we need to understand the ideological backdrop of post-World War II America. We have to understand the national mindset that made such a contract seem not just acceptable, but morally necessary to the politicians drafting it in Washington.
Because you can't just dissolve dozens of recognized communities overnight without some kind of prevailing political theory justifying it to the public, right?
Exactly.
In the early 1950s, the prevailing theory in federal Indian policy was crystallized into a single concept, and that was termination. The official future for Indian country, as envisioned by Congress, was that it simply shouldn't exist as a separate legal entity anymore. And we see this explicitly codified in a foundational document from our sources.
Right, House Concurrent Resolution 108.
Yes, passed in 1953.
Which was really the ideological charter of the entire termination era. Now, a concurrent resolution isn't a binding law in the sense of having enforceable operational mechanisms.
It's more of a statement of intent. Right?
Exactly. It acts as a formal declaration of congressional intent. HCR 108 declared that the official policy of the United States was to end federal supervision over Indian tribes as rapidly as possible. And the specific language they used was ending wardship.
Which is such a deeply paternalistic term. Wardship. It implies that tribal nations weren't sovereign entities with whom the United States had signed treaties, but rather dependents, like children,
Who needed to be raised up and eventually pushed out of the nest. Exactly.
And that is precisely the psychological framework of the era. The language in the resolution framed the goal of termination as an act of liberation. It stated that Native Americans should be made subject to the same laws and entitled to the same privileges and responsibilities as are applicable to other citizens of the United States.
So to the average American reading a newspaper in 1953, this was pitched essentially as an early civil rights initiative.
Right, exactly.
The messaging was all about ending segregation and ensuring everyone was treated equally under the law.
It was a highly integrationist framing. The post-war American ideal was deeply rooted in conformity and individual economic participation. The prevailing mindset was that the highest possible good was for everyone to assimilate into the mainstream. to become ordinary, tax-paying, land-owning citizens.
The American dream.
Right. And from the perspective of the policymakers drafting HCR 108, keeping Native Americans on federally managed trust land was holding them back from that dream. But, that soaring language about equality, it provides excellent political cover. To understand the reality of what was happening, you have to look at the operational laws that accompanied HCR 108.
Right, the laws with teeth.
Exactly. Because in that exact same year, 1953, Congress passed Public Law 280. And unlike a concurrent resolution, Public Law 280 was binding, enforceable law.
It absolutely was. And Public Law 280 fundamentally altered the jurisdictional landscape of Indian country. It transferred criminal jurisdiction and a significant amount of civil jurisdiction over native lands to certain state governments.
Including California.
Right. California was one of the states mandated to take over this jurisdiction. Crucially, this massive transfer of power was done entirely without the consent of the tribes involved.
I was reading the analyses of PL 280 in our stack, and I think the best way to visualize what this law actually did is to think of it like a hostile corporate restructuring.
Oh, that's a good analogy.
Yeah, like the government wanted to liquidate an entity, in this case tribal land and tribal sovereignty. But you can't just liquidate a sovereign entity without violating international law and centuries of treaties, so they changed the legal definitions.
Just rewrote the rules.
Right. Under PL 280, the board of directors representing tribal sovereignty was legally reclassified as mere shareholders or individual state citizens. Once they were just individual citizens subject to state laws and state courts, the parent company, the federal government, could just liquidate the communal assets without ever needing a formal vote from the tribe.
That corporate restructuring analogy perfectly captures the mechanism. PL 280 eroded the legal shield of sovereignty. If you look at what civil and criminal jurisdiction means on the ground, it changes everything about daily life.
How so?
Well, before PL 280, if a crime occurred on tribal land or if there was a civil dispute regarding property or family law, tribal law enforcement and federal authorities handled it, respecting the tribe's internal governance. After PL 280, state police are patrolling the land. State courts are deciding property disputes.
The state suddenly has the authority to step in, nullifying the tribe's ability to govern itself.
Exactly.
By viewing these communities not as sovereign governments, but simply as collections of disadvantaged individuals living within the borders of California, federal policymakers could justify dismantling their communal lands entirely. Freeing them from federal management sounds like a favor when you refuse to acknowledge their underlying sovereignty.
And with that ideological groundwork laid by HCR 108 and the jurisdictional shield removed by Public Law 280, the federal government turned its sights on what were arguably the most vulnerable targets in the entire federal system, the California Rancherias.
Right. And we really need to define what a rancheria was at this time, because it is a land-holding system largely unique to California. These were not the massive, sprawling reservations covering millions of acres that you might picture in the Dakotas or the Southwest.
No, not at all.
These were incredibly small tracts of land. We are often talking about just a few dozen acres, sometimes populated by only a handful of families.
Their history is really important context here. Many of these rancherias were created in the early 20th century. The federal government, recognizing the massive displacement of native populations during the California Gold Rush and the subsequent decades of state-sanctioned violence, began purchasing small parcels of land for what they officially termed homeless Indians.
A horrible term, but that's what they called them.
Right. They were meant to be small refuges, places where displaced families could live communally under federal protection.
And the California Rancheria Act, Public Law 85-671, signed on August 18, 1958, put these specific, tiny communities squarely in the crosshairs. The text of the act specifically names 41 rancherias slated for termination.
41.
Yeah. The lists in our dossiers name communities like Lytton, Hopland, Table Mountain, Penalville, Robinson, Chico, Redwood Valley. 41 distinct communities facing the total distribution of their communal land.
But, and this is key, the legislation was not written as an outright seizure. As we established earlier, the government was presenting this as a benevolent transition. The act contained explicit statutory obligations. The Secretary of the Interior was legally required to prepare these rancherias before any land could be distributed to the individuals living there.
I looked really closely at the explicit requirements listed in the statute, because before handing over the deeds to the land, the federal government had to survey the boundaries of the parcels. They were legally obligated to bring the Bureau of Indian Affairs roads, the dirt roads serving these communities, up to adequate standards, meaning paving them and making them passable year-round.
Right, actual infrastructure.
Yeah, and they were required to install or rehabilitate such irrigation or domestic water systems and sanitation facilities.
The government was offering modern infrastructure. The pitch to the rancherias was essentially, we will draw the official property lines, we will pave your roads, we will lay working pipes, and we will install modern sanitation. And once we have modernized your community, we will hand you the deed to your own individual piece of this land. Or, they could form a corporation or sell it and take the proceeds.
But the fine print of this contract reveals the true cost. Because the moment a member accepted their individual parcel and received that deed, the land lost its federal trust status.
And that changes everything.
Everything. Because the land was no longer held in trust by the federal government, it instantly lost its immunity to local and state property taxes. It also became alienable, meaning it could be freely sold on the open market, stripping away the federal protections that prevented predatory land grabs.
Furthermore, accepting the deed meant the individual lost all entitlement to federal services that were provided to them specifically because of their status as Native Americans.
Oh, wow.
This meant the immediate loss of access to federal Indian health clinics, specialized education funding, and economic development programs.
Wait, so let's put ourselves in the shoes of a family living on the Hopland or Lytton Rancheria in 1958. The government approaches you and says, we will fix your pipes and pave your dirt road. But the second we hand you this piece of paper, you lose your health clinic, you lose your school aid, and the county tax assessor is going to start sending you property tax bills on land your family has lived on for generations without paying taxes.
That is a brutal trade-off.
Was this a fair trade or a trap designed for communities that were already struggling? Because legally and morally, the promised infrastructure, the working water, and the paved roads was the only consideration that made this deal even remotely defensible.
Well, the government's logic, however flawed, was that by providing modern infrastructure, they were giving these individuals the capital foundation needed to survive in the private taxable market. A paved road and a working water system theoretically increase the value of the land and allow for economic development. Right, in theory. But without the water and without the roads, you aren't setting anyone up for self-sufficiency. You are just handing them a tax bill they cannot pay while simultaneously taking away their doctor. Without the infrastructure, this policy was nothing more than dispossession wrapped in bureaucratic red tape.
And what sounds neat and tidy in a congressional committee room in Washington, D.C. rarely survives contact with reality. When we dig into the sources, we find out very quickly what actually happened when the federal bureaucracy tried to execute this complex contract on the ground. And the first entity to notice that the math wasn't adding up wasn't necessarily the tribes themselves. It was the state of California.
Yeah, the state got very nervous very fast. In 1957 and 1958, right as this federal termination policy was being finalized and implemented, the California State Senate Interim Committee conducted its own inquiry.
Because they saw what was coming.
Exactly. The state government realized very quickly that if the federal government strips away health services, education funding, and economic support from thousands of marginalized people living within California's borders, the state and the local counties are going to inherit the burden of caring for those people when they inevitably fall into extreme poverty.
California saw the financial cliff approaching. So state investigators traveled to these rancherias to observe this so-called benevolent preparation process firsthand. And I was reading the state committee's inquiry, and the findings are stunning. There were no fleets of bulldozers paving roads. There were no crews laying water pipes.
Nothing. The state committee found a starkly different reality than the one being promised by federal officials in Washington. The federal government's side of the bargain largely did not exist. The roads were not being brought up to standard. The domestic water and sanitation improvements were completely absent.
Wow.
Yeah, the absolute legal precondition for termination, the infrastructure preparation of the land, was being entirely ignored by the Bureau of Indian Affairs.
It was a massive breach of contract before the ink was even dry. And the state investigators found something even more alarming than the missing infrastructure. They uncovered the shockingly thin bureaucratic process the federal government was using to secure consent from the tribes to dissolve their communities in the first place.
Which is just appalling. If a government is going to fundamentally alter the legal status of a communal landholding and strip away federal services, you would expect a rigorous, democratic, and highly documented process to ensure all stakeholders fully understand the consequences and agree to the terms.
You would think so.
Instead, the state found that notice to the members of these rancherias often consisted of nothing more than a single piece of paper pinned to a bulletin board on the rancheria for 30 days.
Just a piece of paper on a bulletin board. Imagine this in any other context for a moment. A developer wants to buy your entire neighborhood, tear down the houses, and rezone the land. To get the required legal consent, they staple a flyer to a telephone pole at the end of a dirt road. They leave it there for a month. Federal officials show up for one afternoon, talk to the 3 families who happen to be physically residing there that day, completely ignoring the wider tribal membership who might be away working seasonal agricultural jobs or living in a nearby town, but who absolutely have a legal inherited stake in that communal land.
Just whoever happened to be walking their dog that afternoon.
Right. And after that brief visit, the government declares the deal is done. That's not a negotiation. That's a steamroller.
It was the absolute illusion of consent. And the state investigators were rightly alarmed. You had a vulnerable population that was not fully informed of the irreversible generational consequences of losing trust status and health services, supposedly agreeing to a deal where the government wasn't even providing the infrastructure they promised in writing.
So you combine a predatory contract that strips away safety nets with sheer bureaucratic neglect regarding the infrastructure and an entirely hollow consent process. The results are predictably catastrophic. When we look at the actual wreckage, when we trace the economic cascade that hit families living on places like Linton and Hopland, the true devastation of administrative erasure becomes so clear.
The fallout was rapid. Incredibly rapid. The 1997 Termination Report by the Advisory Council on California Indian Policy, the ACCIP, documents the precise mechanics of this collapse. And one of the most jarring details in the entire historical record concerns the loss of federal Indian status services, specifically health care. According to the ACCIP report, federal Indian health services to many of these affected communities were completely discontinued by 1955.
Wait, hold on. We have to highlight the timeline here. The Rancheria Act wasn't signed into law until August of 1958. How did the government discontinue health clinics in 1955?
It was a brutal preemptive strike driven by bureaucratic anticipation.
Are you serious?
Unfortunately, yes. Federal agencies, specifically those managing health budgets, saw the termination policy advancing through Congress via H.C.R. 108. Anticipating that these tribes would soon lose their federal status, the agencies simply stopped allocating funds to the clinics serving the California Rancherias. They just diverted the budgets elsewhere.
So families were losing their local health clinics and their doctors 3 years before the deal to terminate their status was even finalized in Congress.
Yes.
They were suffering the penalties of the contract before they even saw the paperwork. That is insane. And then, 1958 hits, the act is passed. The BIA rushes through the 30-day bulletin board notices, the individual deeds are handed out, the land comes off federal trust status, the state and local authorities now have jurisdiction, and the county tax assessor can now tax the land.
And to understand the shock to the system, we have to look at the economic reality of these families in the late 1950s. The ACCIP report notes that median family incomes on California reservations at this time were hovering around $2,500 to $3,500 a year total. And many of the specific isolated rancherias targeted by the act were even worse off than that average. These were communities living in deep structural poverty, a direct result of decades of prior marginalization and land loss.
They had virtually no liquid capital. Their wealth, such as it was tied up entirely in the communal land they lived on.
Exactly. So dropping sudden recurring property tax bills on these families was a recipe for total economic collapse. If your family's surviving on $2,500 a year, and you suddenly owe hundreds of dollars in property taxes on a parcel of land you've lived on for generations without ever paying a dime, the math simply does not work.
Let's trace the exact economic cascade of a family facing this in, say, 1960. The deed arrives in the mail. A few months later, the county tax bill arrives. The family doesn't have the cash. They can't get a bank loan because banks historically redline Native communities and wouldn't lend against the newly deeded, often unimproved land.
Right, they couldn't borrow against it.
So the taxes go into arrears. The county applies penalties and interest. And within a few years, the county seizes the land and puts it up for a tax auction to recover the debt.
The ACCIP report meticulously documents this sequence. Because the distributed land was now taxable and alienable, families who couldn't afford the sudden tax burdens had their ancestral homes seized through tax sales. Other families, seeing the writing on the wall or falling into desperate debt trying to pay for basic living expenses and private medical care, since the federal clinic had shut down, remember, were forced to sell their parcels to non-Indian buyers for pennies on the dollar.
It's tragic. We talk about termination as a legal concept, but for you listening to this, visualize what this means for a family. You get a piece of paper saying you own your land, but the water still doesn't work. The road is still a muddy rut. Your doctor is gone, and a county tax collector is seizing your home.
Oh, total nightmare.
It was a policy sold on the floor of Congress as a pathway to self-sufficiency and capitalist integration. Instead, it engineered an entirely new generation of deep landless poverty.
And the dispossession was breathtakingly fast. The ACCIP report notes that within a relatively short period of time following the distribution of deeds, significant portions of the communal Rancheria land base passed entirely into private, non-Indian hands. For many of these Dans, their entire land base was lost completely, scattering the community and breaking the physical ties that held their governance and culture together. And the destruction was so sweeping and executed so hastily by the bureaucracy that it leads us to one of the most bizarre and honestly chilling aspects of this entire history. The federal government was processing these communities on such an administrative assembly line that they failed to maintain an accurate record of their own actions.
It's a genuine anomaly in the historical record.
When you look at the historical dossiers, no one can definitively agree on exactly how many tribes were actually terminated under this policy. The numbers simply do not reconcile across the different federal agencies and historical syntheses. Let's break down the competing figures because it's pretty wild. First, there is the literal text of the 1958 Act itself, which explicitly names 41 rancherias.
Right. 41 is written into the foundational statute.
Yes. But then, in 1964, Congress passed an amendment to the Rancheria Act. This amendment added approximately 7 more rancherias to the termination list and adjusted some of the operational procedures regarding sanitation facilities.
Okay, so 41 plus the 7 added in 1964 puts us around 48 communities.
But if you look at broader historical syntheses, for instance, Wikipedia's overview of the California Rancheria Termination Acts, which aggregates various academic sources, they often cite that a total of 46 rancherias were actually terminated.
Okay, 46. That's a different number entirely. So we have 41, 48, 46.
And then, if you go to the Bureau of Indian Affairs, the exact federal agency responsible for executing this policy on the ground, and you look at their press records and official statements from the era, they insist that only 38 rancherias were terminated under the Rancheria Act. The 1997 ACCIP report, which is a major federally commissioned advisory document, also works from this baseline, citing that 38 of the original 41 were terminated.
I mean, think about the staggering implications of this. We are talking about a modern, industrialized government in the mid-20th century, a government capable of building the interstate highway system and launching satellites. Yet they literally lost track of how many sovereign entities they legislated out of existence. How does a modern government just lose track of that? Is this just a genuine bookkeeping error, a typo in a filing cabinet somewhere in the Department of the Interior? Or does this discrepancy reveal something deeper about the level of care taken with these communities?
Well, the discrepancy stems from bureaucratic chaos and shifting administrative definitions. The debate usually hinges on what counts as termination strictly under the 1958 Act. Between 1956 and 1957, a handful of rancherias, places like Coyote Valley or Lower Lake, also known as Coy, were terminated or slated for termination under separate earlier actions before the 1958 Act consolidated the approach.
So the bureaucrats are basically arguing over whether a community was erased under file folder A or file folder B.
Exactly. Do you count those earlier terminations? Do you fold the 1964 additions into the final tally? The BIA says 38 under this specific 1958 statute, while other historians look at the total human impact of the termination era in California and point to 46, or point to the 51 total names across all the various legislative lists.
The very fact that historians and federal agencies have to debate whether a whole community of people was legally erased or not based on technical definitions is just chilling. It shows the absolute danger of treating human communities as mere administrative checkboxes. When you process people on an assembly line, focusing only on closing the file and shutting the budget line, things fall off the belt.
They do.
The contested numbers aren't just historical trivia. They reflect a system so obsessed with the mechanism of termination that it lost sight of the actual human beings it was dismantling.
And recognizing that chaos, the lack of records, the failure to build the infrastructure, the preemptive loss of health care, and the subsequent loss of the land itself, we have to look back at the architects of this policy and ask the most uncomfortable question. What was the true driving force here?
Was it benevolence or the bottom line?
Right. Was this a tragic, fumbling failure of misguided idealism? Or was it a cold, calculated financial maneuver by the federal government?
When you look at the sources, there are two distinct historical arguments regarding the motive. The first is the ideological argument. If we look at the political climate of the 1950s and read the transcripts of the congressional hearings surrounding HJR 108, we see a generation of policymakers who genuinely believed that the reservation system was a complete failure.
They viewed the poverty on the rancherias and concluded that federal wardship and communal landholding were the root causes of that poverty. Driven by the assimilationist ideology of the post-war era, they fundamentally believed the highest possible good was to integrate Native Americans into the mainstream capitalist system.
Make them just like everyone else.
Yeah, they believed that forcing them into private property ownership was the only way to achieve true equality. It was incredibly paternalistic, assuming the government knew what was best for these sovereign nations. But from the perspective of the policymakers at the time, the stated intent was emancipation and integration.
But the historical record, specifically the findings of the ACCIP Termination Report, provides heavy evidence for the second argument, which is fiscal expediency. The ACCIP reviewed the internal memos and the operational reality of the BIA and concluded that the implementation of the Rancheria Act was, in practice, a policy designed to shed federal benefits, services, and treaty obligations as quickly and as cheaply as possible.
The ACCIP report points to a very revealing budgetary arrangement within the bureaucracy that really undermines the benevolent integration argument. When it came time to actually pay for the promised infrastructure, the surveying, the road paving, the water systems, the federal agencies deliberately avoided going back to Congress to ask for special appropriations to fund the work properly.
Wait, why would they avoid asking Congress for the money required to fulfill the statute they literally just passed?
Because asking for millions of dollars in new appropriations would highlight the massive cost of this supposedly benevolent policy. The agencies knew Congress was focused on cutting the federal budget, not expanding it. So instead of securing the necessary funding, BIA officials quietly diverted existing program funds that were already allocated for California Indians.
They robbed Peter to pay Paul, but there wasn't enough money in Peter's account to begin with.
Precisely. The existing funds were entirely inadequate to cover the massive, systemic infrastructure needs of over 40 neglected rancherias. The bureaucracy used budget loopholes to hide the fact that they simply did not have the money to honor the contract. As a result, the work simply didn't get done, or was done so poorly and cheaply that it was meaningless.
Let's be real here. If you truly believe you are emancipating a community, you don't skimp on the plumbing. Doesn't the sheer cheapness of the execution prove that saving money was a real priority and the equality language was just good PR?
Well, you have the stated ideological goals: assimilation, equality, emancipation pointing in one direction. And you have the operational incentives of the bureaucracy: saving money, avoiding congressional oversight, shedding federal responsibilities, pointing in a drastically different direction. And when those two forces collide within a government agency, the bottom line almost always wins.
It always does.
The systemic failure prioritized fiscal expediency over honoring federal statutory requirements. But, and this is the fascinating part, that exact bureaucratic decision, the choice to save money by cutting corners on the infrastructure, ends up becoming the loaded gun that unravels the entire policy decades later.
We've established that the government wrote a contract. They forced it upon the rancherias with minimal 30-day bulletin board consent. They failed to deliver the promised infrastructure, deliberately hiding the budget shortfalls. And then they ruthlessly enforced the penalties of the contract, allowing the counties to tax and seize the land. But as we know, in contract law, a broken agreement is a two-way street.
Absolutely. If you sign a contract to buy a house, and the seller never builds the roof or installs the plumbing as promised, you are not legally obligated to hand over your life savings.
Right, the deal's off.
The legal term for this is a failure of consideration. In the context of the Rancheria Act, the failure to survey the land properly, to fix the BIA roads, and to install the sanitation systems wasn't just a moral failing. It was a massive statutory breach of public law, 85-671.
By failing to provide the infrastructure, the federal government failed to provide the legally required consideration that made the termination of trust status valid in the first place.
And this brings us to a name that changes the entire trajectory of this history: Tilly Hardwick. In 1979, Tilly Hardwick, a Palma woman from the Pinalville Rancheria, became the lead plaintiff in a landmark class action lawsuit against the federal government. Hardwick v. United States completely reframed everything we've just discussed about the bureaucratic neglect of the 1950s.
And while we aren't going to resolve the entire complex history of the Hardwick lawsuit today, we have to look at the legal strategy they used because the irony is staggering.
It's incredible irony.
The government was in such a massive rush to cut costs, to shed their treaty responsibilities, and to assimilate these communities quickly and cheaply that they completely failed to cross their T's and dot their I's. By withholding the consideration, the water and the roads, they handed Tilly Hardwick and the Rancherias the exact legal sledgehammer needed to shatter the termination policy years later.
Hardwick's legal team looked at the dirt roads and the dry pipes not just as symbols of oppression, but as a foundational legal wedge. The argument was brilliantly simple and devastatingly effective. The 1958 Act explicitly required the government to install water and roads before distributing the land and stripping the trust status. The government demonstrably did not do it.
And since they didn't do it,
Therefore, the distribution of the land was legally invalid. And if the distribution was invalid, the termination of the tribe's sovereign status was invalid.
the statute essentially indicted itself. The very failure that caused so much suffering, poverty, and land loss for places like Lytton and Hopland in the 1960s became the exact loophole that allowed them to fight back in federal court in 1979.
It is a profound reversal. The bureaucracy's obsession with fiscal expediency, their refusal to pay for the pipes, was the very thing that allowed the tribes to eventually reclaim their recognition.
It really makes you look at the arc of history differently. Let's recap the journey we've been on today. We started with the grand, sweeping ideological promises of House Concurrent Resolution 108 in 1953, the paternalistic push to end wardship and force assimilation. We saw how that ideology was weaponized into the 1958 California Rancheria Act, a contract that demanded sovereignty in exchange for modern infrastructure.
We examined the stark reality uncovered by the state investigators, the missing roads, the dry pipes, and the deeply flawed illusion of consent based on 30-day bulletin board postings.
We traced the devastating economic cascade federal health clinics closed preemptively in 1955, families surviving on a few $1,000s a year suddenly losing their ancestral homes to county tax auctions because they couldn't pay the sudden property taxes. We waded through the chilling, chaotic bookkeeping of a government that couldn't even definitively count if it had erased 38, 41, or 46 distinct communities.
Such a failure on every level.
And finally, we saw how that sheer bureaucratic cheapness set the stage for Tilly Hardwick to use the government's own broken promises against them. The California Rancheria Act serves as a profound case study in how federal policy actually operates on the ground, far away from the polished rhetoric of congressional committee hearings.
It really does.
And I want to leave you with something to ponder long after this audio ends. When we think of historical injustices, our minds usually jump to images of overt hostility. We picture armies or violent, dramatic confrontations. But the story of the California Rancheria Act shows us something much quieter and, in some ways, much more insidious. It shows us that sometimes the most profound devastation a government can inflict is delivered by bureaucrats armed with 30-day notices, unmet infrastructure budgets, and soaring, benevolent language about equality and emancipation.
Yeah, that's a powerful point.
So it asks you to consider, in our modern world right now, where else are we accepting the benevolent titles of laws and policies without looking closely at the fine print of the actual on-the-ground outcomes? Thank you for joining us on this deep dive into the sources. Keep digging, keep questioning the official narratives, and we'll see you next time.